Hey, it's Ben. Rahul and I started this podcast because we love hanging out with fellow trial lawyers and sharing ideas that can make us all better. And both of our firms also regularly collaborate with other lawyers across the countries in cases where we can add value. If you're interested in collaboration, or even if you just have a case or an idea that you want to bounce off us or brainstorm, Rahul and I are going to be hosting confidential case workshops the first Wednesday of each month. So here's how it works. If you have a case or an idea that you want to talk about or brainstorm with us, just send me an email to ben@elawvate.net, ELAWVATE.net, or go online to elawvate.net and submit a case workshop request. We will schedule you for a confidential 30-minute Zoom meeting where we can talk about your case to see if we can help. If you feel like there would be good value in collaborating on the case further, we can talk about that. If not, that's okay too. We enjoy helping other trial lawyers because we know someday you'd be willing to do the same for us if we needed your help. So again, if you're interested in workshopping your case with us, just send an email to ben@elawvate.net or fill out a case workshop request at elawvate.net. And Rahul and I will look forward to chatting with you soon. Today's episode of Elawvate is brought to you by the Expert Institute. Rahul, you guys use Expert Institute, right?
We do use Expert Institute, and it's fantastic to get different experts in different fields, but the best of the best. And you don't know until you do the research, and they do that all for us.
Today's show is also brought to you by Filevine. Filevine has a platform called Lead Docket, which is the state-of-the-art way of tracking all of your intakes and leads, particularly if you're putting money into advertising. You don't want to waste money by missing a lead or missing a good case. It also doesn't mess up your case management software by keeping it in a different platform just focused on your leads. So check out Lead Docket by Filevine. Also brought to you today by Steno. Steno is a product you've used a lot, Rahul, right?
Steno is fantastic as a court reporting company. In addition to that, if you haven't tried Transcript Genius, it is an AI-based search engine where you can ask it questions such as, with an entire case, all the evidence on negligence, and it'll pull all the deposition testimony from all of the witnesses and put it together in a seamless way with hyperlinks to the actual text. Amazing.
And if your state law allows it, you can also defer the cost of depositions till the end of the case, which is, we were just going through our budget, and transcripts from depositions is in the top 5 of our expense items. So it's worth checking that out. Our show's also brought to you by Smart Advocate. That's the case management software we use at our firm. Our staff loves it. We love it. Very intuitive, very robust, can be adapted to do a lot of different things from mass torts down to small PI firms. So take a look at that. Finally, Hype Legal is the firm that we use for our social media and for our website design and development. We just rolled out our new website about 2 months ago that was designed by Micah and Tyler at Hype Legal. We love it. We've had a lot of great response to it. So if you want to see their work, come to our site at gideonason.com. And if you like what you see, contact Hype Legal and see if they could do the same for you.
Welcome to the Elawvate podcast. I'm Rahul Ravipudi.
I'm Ben Gideon.
Ben, are you excited? So tomorrow is a really special day in our podcast. It is the NFL draft. I'm sure you're all pumped up for the New England Patriots.
I'm very excited about it. We've found our next quarterback, so we now just have to fill in around him. And, I think we're going to create a new dynasty. What do you think? Take on those Buffalo Bills?
I really hope not. I mean, the Chiefs are enough for us to deal with, and I'm just keeping my fingers crossed we fill up our defense, and then this is going to be our year, Ben. This is going to be our year. I did tell you this, right? I talked to my 16-year-old after the Bills lost to the Chiefs this year. He looked at me, he goes, "Why are you getting all worked up?" And then he paused for a second. He goes, "I get it." He goes, "Dad, you got to understand, you don't have a lot of time. I got a lot of time, so I can wait for the Bills to win." And that hit hard. But it was true.
Well, when you're a Bills fan, you need time.
I do.
And it's a long time, but good luck with that, Rahul. And pleased to see your Lakers evened up the series last night. So
I was there last night. It was awesome.
For all of those folks listening to this podcast who want us to move on to the business of trial law, we can move away from sports for the moment. But We do actually have a guest here, Brian McKeen, stellar trial lawyer from Detroit, but that does kind of call into question the whole, bad boy attitude there in Michigan and Detroit. What's your take on all that, Brian? You a Pistons/Lions fan?
The bad boys were the best. I mean, what a great team. The essence of a team, teamwork, hard work. I mean, they came to play, they brought it every night, and they were a lot of fun to watch. And it's been a long time since the Pistons have been any good, but, in the playoffs now, so kind of exciting.
Yeah, they actually have a pretty good team. I loved that rivalry with the Rick Mahorns and Dennis Rodmans, and that was because he was on the Bulls, but
Well, no, he was on the Pistons.
he was on the Pistons.
Yeah, he went to the Bulls.
Bill Laimbeer, that whole crowd.
I remind my friends from Chicago that the Bulls didn't get really good until they had Dennis Rodman.
So, do you think that attitude translates over to what it's like to be a trial lawyer? You guys throwing a lot of elbows.
Well, hopefully nothing that's going to wind up with a complaint with the Attorney Grievance Commission. We try not to throw elbows, but things get a little testy now and then, and litigation is not for the shy of heart, or the faint of heart, I should say. It's tough, and we fight hard. Our opponents fight hard, and yeah, there's some analogy to sports, I think. No doubt.
And that's probably a good segue. I mean, I know that your daughter is a stellar golfer, and I know you're still kind of hold your own on a golf course.
Oh, well, I try,
I'm not a golfer. Right? Rahul, you're not a golfer, right?
I'm like a 3-time-a-year golfer, so the worst kind.
A heck of a tennis player, though, with those massive calves. Brian, I'm assuming you were an athlete as a young man.
Yeah, I love sports. I really did. It was much more important to me growing up, I'm sorry to say, than school was. But I played soccer, hockey, track, and I didn't really take up golf until later after law school. Obviously, I'm not running around at my age playing soccer or running track, but golf, is an important part of my life. I like to have some outlet away from work and enjoy having something to work hard at, working toward goals, trying to get better. And I really love that.
How does that work in the wintertime, though?
Well, you get out of town as often
Yeah.
as you can. We do have a simulator down in our basement, so you can swing down there. Yeah, it's also nice to have a little bit of a break from golf. I mean, I try and work on it in the summertime and through the fall, and then it's nice to kind of put the clubs away a little bit and, focus on other interests.
So then what's your handicap?
I'm about 6 right now.
Jesus.
How do you fare against
Amazing.
your daughter?
She plays her best. I have no chance. If she struggles a little bit, I might be able to nip her.
She played golf in college.
Yeah, she played at Hamilton College in New York. Yeah.
So take us back when you were focused on sports and not on school, and then somehow they parlayed that into graduate school, law school, and then getting into the world of trial law. How did all that happen for you?
Yeah, I don't know. My dad was a brilliant engineer, mechanical engineer.
So you worked
Graduated
at a
University of
car
Michigan.
Oh, okay.
Yeah, he was Cadillac Motor Company and then General Motors. He retired as the chief of engineering analysis at General Motors, and then started a consulting firm and worked with law firms and auto manufacturers on product recalls, crash investigations, things of that nature. My brother was a brilliant chemical engineer, PhD from University of Michigan, undergrad, master's degree, PhD from Michigan, all in about 6 years. I mean, just a brilliant guy. And I was kind of the dunce of the family, didn't really care about school, was turned off academically. And when I went to college, I just sort of turned the corner a little bit and got a little more interested in learning and studying. And then decided I wanted to go to law school. Didn't necessarily know I wanted to be a lawyer yet, but thought it might be great training for whatever I decided to do in life. And then I had the opportunity in law school to clerk for a circuit judge in Oakland County, Michigan, outside Detroit. And I got to see a lot of trials. And I thought, wow, this is really interesting. This is intellectually stimulating. It's exciting. Every case is different. I think this would be a really cool career path to pursue.
And did you think when you first saw that would fit with your personality and that you'd be good at it? Or did you think, well, this is something I can aspire to, but I'm going to need to acquire some skills and train myself to?
Yeah, I think it was more the latter, without a doubt. But I thought, heck, if these guys can do it, I think I could do it. I mean, I'm not saying go do it tomorrow, but I could learn how to do it. And then after that, I was really fortunate to get an opportunity to get an internship with the Prosecuting Attorneys Association of Michigan. So I spent a summer. Well, first of all, you go to state police headquarters in Lansing, you get some training, and then they send you off to some faraway county. In my case, I was in Bad Axe, Michigan, and Huron County, up on the tip of the thumb of the Lower Peninsula, and got to try cases. Got to do hearings. I actually tried a jury trial on Monday of my second week on the job. I got a felony conviction. And it was just unbelievable experience for a young person. And I thought, wow, I can do this and I can do it well. And it was really a positive experience because the prosecuting attorney, the local judges, court staff, when I left, they go, hey, you're going to be a great lawyer. And that was a very empowering experience. It really was. I thought, wow, people believe in me.
Is that something you could replicate today, do you think? Is there the same opportunity there?
Yeah, I do. I still think they have that program. I think that program's out there. I don't know why we don't have more really talented young people interested in pursuing careers in the plaintiff bar. There is a new organization, I can't remember what they call it, but the Plaintiff Law School Attorneys or something, Future Plaintiff Attorneys. I think we really need to nurture that organization. And I don't know that we have more than one chapter in Michigan. I think we've got a law clerk at our firm who is involved in a chapter at his law school, Cooley Law School, which is where I went to school. But I don't know if there's any other chapters. And I really, in my spare time, I'm speaking facetiously, but I've been meaning to make time to try and, visit these law schools and encourage them to start programs at their schools too.
So in Michigan, focusing really on the practice of being a plaintiff trial lawyer, is that not a growing profession? Is it shrinking over there?
Well, yeah, I think that there have been a lot of great trial lawyers or good trial lawyers anyway who've, aged out and retired. I think that there's been, a big move toward ADR. And I think there are fewer and fewer great trial lawyers coming up because I don't think they get the same opportunities to try cases that we had when we were coming up. Back then we didn't have all these expert witness requirements. Now in a medical malpractice case, you might have 6 different specialties or subspecialties. Back in the day, you could retain one expert, and as long as they said they knew a little bit about each of those 6 areas, you could qualify them as an expert. Now you've got to have, 6 experts, one to match each defendant, pre-suit filing requirements, notice of intent requirements, 182-day waiting periods, things of this nature. And it's made malpractice litigation much more time consuming and expensive. And it's harder to give young people an opportunity to go try a case because you've got so much money invested in the case.
I have a question on that. Never really done the history research on it, but just kind of living it. Why has it gotten so difficult to, cost prohibitive, labor intensive, and everything? Has it made the profession better or more problematic?
Well, definitely more problematic, I think. I mean, I think that when you file a medical malpractice case, that's a serious thing, and you ought to have a sound basis for making a claim against a medical professional. But I don't think it should be ridiculously expensive to have to litigate it, and it is ridiculously expensive. In some cases, it's almost cost prohibitive. I mean, there's a lot of doctors in Michigan, and I'm sorry, I'm suffering from a terrible cold, but there's a lot of doctors in Michigan who carry $200,000 of insurance, sometimes 100. That's all they have. And they've worked with estate planning attorneys to put their assets in trust so that you can't collect them. And it might cost you tens of thousands of dollars or more, to prosecute that case against that doctor. And it becomes hard to find attorneys who are willing to put in all the hard work, spend the money with no real significant economic upside.
In those early days when you were prosecuting criminal cases in the northern part of Michigan, what did you learn from that process? I mean, I'm assuming you had a lot of reps in the courtroom. And what did you take?
It was a quick summer, but
did you acquire some skills or insights from in those early days that have helped you as you move forward?
the only thing I would say that is just that it's not rocket science, and I would encourage a lot of people who think that maybe they don't have what it takes to be a trial lawyer to reconsider. You figure out the facts of what happened, who committed this crime, how'd they do it, how you're going to prove the elements of the crime. And it's really, not all that difficult. And it's the same with what we do, establishing the elements of a medical malpractice claim or a personal injury claim. If you just approach it with a thoughtful, analytical approach, I think a lot of people could be very good at doing this, but they have to have, the courage to stand up in a courtroom. And a lot of people are scared to walk into a courtroom. It is a scary thing. And you have to have, an innate belief in yourself and then trust yourself as an advocate who's going to be persuasive to others. And I just think that getting those reps and having some success in the court and getting positive feedback from court personnel, I think it really helped me, mature into someone that could go out there and, become a successful trial lawyer. And I wish a lot of other young people had that opportunity.
Where did you start your private practice career? I noticed on your website you were a partner in another firm first and before Brian McKeen and Associates. Is that where you kind of started?
Yeah, actually, when I graduated law school, I clerked for a Michigan Court of Appeals judge who later went to Michigan Supreme Court. And then, long story, but she was removed from office in a political controversy about whether or not the lame duck governor had the authority to make an appointment to the Supreme Court when the incumbent had just been reelected. This guy was reelected in November. She ran for the Supreme Court, very narrowly lost. On Thanksgiving Day, the incumbent who had just been reelected dropped dead of a heart attack. Turned out to be a case that was litigated, by the way. And the outgoing governor appointed her to the seat. And when the new governor came in, he contested the authority of the outgoing governor to make that appointment. The long story short, she was eventually removed from office. Later went on to run again and be reelected to the court. But I started working for a guy named Tom Blakely. Tom had just left the Scharfus and Christensen firm, which is a well-known plaintiff firm that did a lot of medical malpractice and product liability. Tom was doing a lot of drug product liability. I came on with him. I think I was the third lawyer in the firm. And then Tom retired. I think I started with Tom in 1983, and Tom must have retired around 1995. And I just took over the firm after Tom retired. So the name switched from Blakely and McKeen to McKeen and Associates.
So you've been a lifer at the same firm.
Yeah.
And then how was that experience, the transitioning from having Tom Blakely there and then moving it into you running the whole place?
Well, it was pretty seamless. I'm grateful to him for the opportunity that I had. And I don't want to say anything derogatory, but it was time for him to step away, and we made a very seamless transition, and it was awesome.
You have a large firm now, range of about 20 lawyers, right?
Yes.
That's a big undertaking to not only try cases at the pace and complexity that you do, but also managing that business. How do you, I guess that's where the tongue-in-cheek joke about in your free time came from, but
Right.
how do you balance all that?
I don't know. I work 8 days a week. No, it's a difficult balance, but I've tried to put in place a good team. I've got a managing attorney, an office administrator, a couple of bookkeepers, and I like the firm to try and run itself as much as possible so I can focus on litigation, focus on my clients and the things that are really important, to our firm. Got to be involved in the administration to an extent, but I like to minimize the extent to which I'm involved in personnel decisions and things like that. You've got to empower other people to take the lead on that with advice and consent from myself,
And how do you structure the workflow? Are you coming in and trying all of the high value cases? Are other lawyers trying those cases independent, or how do you do that?
On a baby case, a catastrophic injury case, I'll be the trial lawyer. But we've had most of our attorneys, if not all of our attorneys, that are litigating cases. And we have about 10 litigators and about 10, support attorneys. They've all had verdicts and they've all been in the courtroom. They've all won. These are guys and women who are capable of going in and winning, on their own. I try and, involve myself in as many cases as possible. I look at every single new client interview. I make every decision about whether or not to investigate a case. And then as a group, we make a decision whether or not to go forward with further investigation and then whether we're going to go forward with litigation. I try and take as many of the defendant doctor depositions as possible, particularly in the high value cases, and the defense expert depositions. And we use staff attorneys to, cover things like the plaintiff's deposition, for example, and cover our experts' depositions. And that way I can leverage, my abilities to do the things that are the most important and where I think I can have the greatest value in affecting the value of a case.
And are you primarily handling med mal cases? I know you also do other types of plaintiff's work, and I'm familiar with your $96 million verdict in the trucking case, which we could talk about in a bit. But how does your work break down into different types of cases?
Yeah, that's a case I tried with Tom Moore and Judy Livingston from New York, by the way. Tom was the lead trial attorney at trial. But no, we do the whole gamut of personal injury, civil rights. I've got two really great civil rights cases now involving prisoners in jails, one of whom died a totally preventable death after he was ignored all night in the midst of a medical crisis. Another involving a young lady who broke her neck falling out of a bunk bed and was ignored for 4 days in her jail cell, reporting she was having difficulty moving. She was dragged around like a sack of potatoes, and as a result, she eventually experienced a severe spinal cord injury and became paraplegic.
Yeah, I'm very interested in those cases. We have a similar case that we're working on where an inmate died from pneumonia, having been ignored by the corrections staff and jail medical staff for days. What is the status of your medical jail case, and have they filed motions? Are you set for trial?
On the death case, we just survived motions for summary disposition in federal court, and the case is going to be scheduled for trial, and we're really excited about it. All the depositions have been done.
Can you just tell us a little bit more about that case, what the issues are and how you put it together and overcame summary? Is this a 1983 case, or what? Tell us a little bit about that.
Yeah, 1983 case. Gentleman in his early 50s. He was a little bit intellectually challenged, but he lived with his mother, was divorced, had 2 adult children, no criminal history, was on a few psych meds. Family was over, they work in the yard, and the dispute came up about how he was doing a certain task in the yard. He got into a fight with his brother-in-law. Some punches were thrown. Police were called. Now, this is a guy who's never been in trouble, never been arrested, no record whatsoever. When his family called the police, he kind of freaked out. He went and he popped a bunch of pills. Nobody knew for sure what they were. Turned out it was trazodone. The police came and picked him up, took him to the local jail. In the jail, the nurse was asked to clear him for admission to the jail. She recognized he was unstable and needed to be cleared at the hospital. He was having difficulty walking. He really wouldn't answer questions, or actually couldn't answer questions because he was under the effects of an overdose of medication. He was taken to the hospital where he was negligently discharged despite the fact he had an abnormal EKG showing a prolonged QT interval, which sets the stage for a potentially fatal arrhythmia called torsade de pointe. He also had some abnormal labs, including an abnormal level of potassium that could precipitate the risk of a fatal arrhythmia. He's in a holding cell. When he comes back from the jail, he's in worse shape than when he came back from the hospital. And by the way, before he left the hospital, the doctor had asked for a urine sample. The nurses noted he couldn't stay awake long enough to give a urine sample. Let him go back to the jail. When he gets back to the jail personnel recognized that he still wasn't cleared for admission to the jail, so they put him in a holding cell. And this is all on video, Ben. So the video shows he had a great deal of difficulty standing up on his own. He needed maximal assistance to get up off the bench, would fall over if he wasn't being supported. Then sometime in the evening, he vomits all over himself, copious vomit, and just lays there in it, leaned up against this wall of his jail cell and doesn't move for 12 hours. And of course, when someone vomits, that may herald the existence of an acute medical crisis. You don't know why they vomited. And it's distinctly abnormal behavior to just sit there and lay in your own vomit without getting up to try and clean yourself off, rinse your mouth out, ask for fresh clothing, what have you. And they just ignored him. And he laid there all night. And in fact, they brought him his breakfast in the morning. He didn't take his breakfast. They belatedly realized he's dead. And this was 100% preventable because he could have and should have been taken back to the hospital, could have been treated for the drug overdose. Some debate about whether he died of an arrhythmia, whether he died of aspiration of vomit, but in either case, death was an absolutely 100% preventable occurrence. So that's what that case is about. This is a patient who never should have been sent back to the jail from the hospital, and the jail should have immediately sent him back to the hospital. Interestingly, we showed the video to the sheriff himself and their expert, who had to concede that not getting someone to come in and evaluate this patient, this inmate, if you will, is deliberate indifference. So we're very confident that a jury is going to do the right thing in that case.
If they acknowledged that, what was the basis for their dispositive motion?
Oh, that we didn't prove deliberate indifference, that there was no failure to train their personnel. And the court saw through that and wrote a really good opinion dismissing those motions.
That's a compelling set of facts. Those are really hard cases. And it's great that lawyers of your skill
Well, they can be, but this is a very righteous case. And, how does any human being let another human being lay there all night knowing that they've taken a number of pills that nobody knows what they were, and leave them laying in a pile of their own vomit, not moving? It's just unconscionable.
An important part on that, from your perspective, is an important part on that case, the fact that the decedent didn't have really any criminal background or prior bad conduct?
Yeah, no, nothing whatsoever. He's very devoted to his mother, took care of her home. Nobody wants to be measured and judged by what they did in the worst day of their life. And that apparently was the worst day of his life. And he shouldn't have had to die because of it, though.
How does jury selection happen in a case like that? What is the defense looking for in a prospective juror, and what are you looking for, and how much latitude is your judge going to give you in learning a little bit about your prospective jurors?
If I had a crystal ball, Rahul, I would answer that question. I mean, it remains to be seen, I think. And I'd really rather not at this point get into what we're looking for and, what I think they're looking for. But, obviously we're going to be looking out for people who have a background in law enforcement, who are going to be sympathetic to law enforcement personnel. And we're just looking for people who are open-minded, not necessarily beholden to law enforcement and willing to stand behind them no matter what. There are jurors who, they believe in supporting the police, law enforcement under any circumstances. And as long as we have people who don't feel like that, who are open-minded, I think we're going to be just fine.
And you said that's in federal court?
Yes.
Is that which district?
Eastern District of Michigan.
So you'll be in Detroit, downtown
Both
Detroit?
cases are, yes.
Yeah. I mean, just in terms of the jury population, I had one case that was scheduled for trial. In fact, we were right on the eve of trial when it resolved, but it was in the Eastern District, and we had gone there and done a series of focus groups throughout the areas that they pull from for jurors in the Eastern District. And I was struck at the vast differences in the populations between the inner city Detroit jurors versus the Wayne County or suburbs. So you get a wide diversity of folks there, right?
Absolutely. Yeah. You have some of the worst slums and then some of the most affluent suburbs all in the same county or the same district.
And what are juries in Detroit like?
Well, it's highly variable. Sometimes you can get all white juries. You can get mixed juries. I think that they're by and large fairly representative, but I think that, a number of years ago, the chief judge in Wayne Circuit sort of changed the way that they drew jurors. And, for whatever reason, it was known that fewer jurors from Detroit would respond to subpoenas for jury service. So that Detroit jurors, and you can read that as ethnic minorities in many instances, were showing up less frequently than people from the suburbs, i.e. white folks. And so I think minority populations were underrepresented on our juries. And I think to some extent that's still true.
Take your playbook to the next level by joining a legal network of all-stars at psrplaybook.com. PSRplaybook.com is a free digital legal library created exclusively for plaintiff lawyers by the nationally recognized personal injury law firm of Panish Shea Ravipudi LLP, and features video content showcasing the tactics, strategies, and concepts implemented by some of the industry's most successful trial attorneys. PSRplaybook.com promotes learning, shared knowledge, collaboration, and best practices. Get in the game and see for yourself by joining our national network of plaintiff lawyers. Subscribe now at psrplaybook.com and learn from the best.
Tell us a little bit about I was reading the news accounts of the case. I think it's Florida Health System's birth injury. Is this a birth injury case?
Yeah, the Drake case,
Drake, correct, right.
Drake versus Henry Ford. Yes,
Yeah. K. John Drake.
K. John Drake. Yeah.
Can you tell us a little bit about that one? It
Yeah.
resulted in a $120 million verdict.
Well, that's a little asterisk next to that. You know, in Michigan, we have a long verdict form, and the jury had over $120 million in past and future damages. It was reduced because of caps and reduction of present cash value to a judgment of about $53 million, I think. 52, 53 million. Case is currently on appeal. We survived all post-trial motions. I think K. John's probably 14 years old right now. His mother is a single African-American mom. Case had been declined by a couple of other law firms. I looked at the case and I saw potential immediately. I had been involved in other cases that were similar. There were a lot of things that, you know, at first blush might scare away a lot of attorneys. Single mom, teenage mom, no actual prenatal visits. There were maybe 6 presentations to OB triage during the pregnancy. She smoked a couple cigarettes a day. There was a reported fall a week or so before delivery. Her mother had later reported, I think erroneously, that there was decreased fetal movement because mom never said there was decreased fetal movement, and the fetal monitor showed the baby's moving. But she turns up at OB triage at term, and the strip is not 100% reassuring. There is some variability, which we were able to get concessions from all the care providers and the defense experts that the baby still was not metabolically acidotic. The strip soon became one of predominantly minimal variability with a lack of accelerations, which indicates, you know, there should be concern about fetal well-being. They did an acoustic stimulation test, seeing if they could provoke an acceleration in the baby's heart rate, and they didn't get one. And when that happens, you need to be definitely concerned about the possibility of fetal acidosis. There was an A1 publication at the time that said that a failed vibroacoustic stimulation test may indicate as high as 50% of babies are acidotic at that point. There was then about a 2-minute deceleration followed by a return to baseline, and then a 7.5-minute severe variable acceleration. And although there was a return to baseline, the staff appropriately recognized that they needed to, you know, call a cesarean delivery. They called the cesarean for what they termed non-reassuring fetal heart tracings. Now, the defendant doctor wrote in her note that it was called for non-reactive fetal tracings. Now, non-reactive would mean there's no accelerations. Non-reactive is different than non-reassuring, which is a little bit more sinister. The strip was not only non-reactive because it didn't have accels, it was non-reassuring because there was minimal variability and there was very severe prolonged deceleration from cord compression. They removed the monitor about 50 minutes before delivery, and from the time they called the cesarean until the time they performed it was, if I'm remembering correctly, around 2.5, 3 hours. And when the baby was born, he was depressed, he was acidotic, and unfortunately he had aspirated meconium. The case could be easily missed because the baby's never diagnosed as having hypoxic ischemic encephalopathy. He was diagnosed as having meconium aspiration syndrome, persistent pulmonary hypertension. He required ECMO, and after ECMO, he had a severe brain bleed. So I had known from other birth trauma cases that, per the literature, babies don't aspirate meconium in utero unless they become asphyxiated. If they become asphyxiated, that can trigger a gasp reflex, and then they inhale meconium into their airways, and that causes the meconium aspiration syndrome. So this baby had meconium aspiration syndrome, which can lead to pulmonary hypertension. The baby had asphyxia, which can also cause pulmonary hypertension. And the truth is that the baby had ultrasound before the ECMO that suggested hypoxic ischemic brain damage. Now, the defense contested it, but the defense radiologist had said consistent with hypoxic ischemic encephalopathy. So I put I saw the case in my head when I was investigating it, and I sort of manifest how I saw it through discovery. Defendant doctor admitted that babies don't generally aspirate meconium unless they're asphyxiated, admitted the baby wasn't, and their experts admitted this as well. Baby was not asphyxiated when mom came in. The baby was asphyxiated at the time of delivery. So the likelihood, obviously, is the baby aspirated meconium while they were screwing around waiting to do a cesarean section. And obviously, the meconium aspiration syndrome was a major factor in the PPHN as well as the birth asphyxia. And the baby wouldn't have been on ECMO if it hadn't been asphyxiated and aspirated the meconium, and probably wouldn't have had a brain bleed if the baby didn't already have hypoxic ischemic injury. So they chose to defend the case by trying to walk away from their own records, which said they called this cesarean for non-reassuring fetal heart tracings. The defendant doctor said over and over and over again in her deposition, the real reason was it was just non-reactive, not non-reassuring. Now, of course, the record said in about 15 different places, no, this was called for a non-reassuring fetal heart tracing. We got the defendant nurses on the stand in trial, all of whom admitted when you call a C-section for non-reassuring fetal heart tracings, the standard of care is to complete it within 30 minutes, not 2.5 hours. And there was absolutely no reason why they would have prolonged this delivery. The defense then tried to walk away from the notion of meconium aspiration syndrome. They retained Jay Goldsmith, who anyone doing birth trauma cases out there in the United States probably knows of Jay Goldsmith. I called him the Prince of Alternative, the Prince of Darkness, and Sultan of Alternative Causation Theories. He opined that no, there wasn't really meconium aspiration syndrome, like the Henry Ford record said, like the Children's Hospital of Michigan record said. There was actually just chronic hypoxia in utero that caused chronic remodeling of the lungs, and that caused PPHN. It was going to mandate the kid got ECMO, and the kid's going to have a brain bleed on ECMO. It had nothing to do with the intrapartum asphyxia. And, he's in the unfortunate position of, I could say to him, well, for you to be right, Dr. Goldsmith, every doctor at Henry Ford who diagnosed meconium aspiration syndrome, every doctor at Children's Hospital of Michigan who diagnosed meconium aspiration syndrome must be wrong. And he said, yeah. And that kind of thing just is not credible. And then the real kicker was we called the defendant doctor on the stand, and she was just a horrible witness. And after about an hour or so of being impeached over and over and over again with her own deposition, she finally admitted that the strip was never reassuring, and it was always non-reassuring. And so it was really turned out to be a slam dunk, unanimous jury verdict that there was negligence in failing to expedite delivery of that baby.
First of all, congratulations on that case. Second, there's so many important lessons in what you just described, because, to me, it illustrates how critical it is for clients to get themselves to the right lawyer who can put that together the way you did and understand and comes to it with curiosity, true curiosity about what happened, and isn't just making assumptions or accepting things at face value without further investigation. And you clearly do that. But the other thing is that you're so conversant in the medicine and have innate understanding based on prior cases that you could spot issues that other people would miss. And I always get a kick out of the folks who say, well, medical malpractice cases really aren't about the medicine, because actually they are about the medicine until you know it well enough.
Certainly about the medicine.
Right.
Yeah.
You have to know it at the threshold level to get yourself over that hump, and then you can make it not about the medicine. So I guess my question for you is, so you just ran through a lot of very complex things that probably many of our listeners who don't do birth injury cases wouldn't understand. And many jurors probably don't understand any of that either. Where is that point of leverage where you can translate what you just described into something that would resonate with regular folks on a jury, and they just get it? They get that you're right about it, that Jay Goldsmith is full of it, and they should find for you in this case.
Yeah, that's a hard question to answer. That's kind of the essence of what we do. You've got to not only have the knowledge to figure out what happened, you got to prove it to a lay jury, And I don't know if you remember the movie Philadelphia. and that great actor who played the attorney. You'll help me with his name, Denzel Washington, I think. And he would be talking to an expert witness and he'd say, explain it to me like I'm a 6-year-old. I often say that to our experts. I want to understand the case on a very basic level and understand how I can explain it, to the jurors. And it's not that difficult to, show the umbilical cord, and that's the baby's lifeline. This is where the oxygen comes from. And if you're pinching the cord, you're pinching the baby's, lifeline, and you're compromising the baby's circulation. You can show a 7.5-minute severe deceleration and show this baby's lifeline being compressed. And this baby's telling the world, I can't breathe. I'm not getting enough oxygen. And you make analogies like that. And then when you can't breathe and you're, then you gasp, trying to, natural physiologic reaction, people can understand that. And if there's this meconium that's been passed in a term pregnancy, that baby can aspirate that meconium. And then you've got this stuff in your lungs. It may make it difficult for your lungs to function normally. And you're going to need, support. And in this case, the kid, developed this persistent pulmonary hypertension. And that was a kind of a complex thing to explain, but we did a pretty good job of explaining that too, where, in utero, the circulation goes one way, and after birth, it reverses and goes the other way. But baby's in big trouble if after birth, it doesn't convert to normal circulation. And so I think we did a great job of explaining all this to the jury, and they understood that if it wasn't for that asphyxia that occurred probably in the last half hour of intrauterine life when the baby's off the monitor, which, by the way, how dumb is that to call a cesarean section for non-reassuring fetal tracings and then take the monitor off? So your early warning system is taken away from you. I mean, remember, this is a pregnancy that featured a 7.5 minute severe deceleration. Something like that had undoubtedly occurred in the final half hour of the intrauterine life, and it was missed. And so they didn't take steps to, mitigate it by repositioning the mother, getting the baby up off the cord, etc. And all this set the stage for this baby's severe illness and the need to have this ECMO. And, the truth is maybe 25% of all babies who undergo ECMO have brain bleeds, but the majority don't. And a big risk factor for why a particular baby would have a brain bleed is because the baby already had hypoxic ischemic injury to their brain.
Well, amazing work there. And I would encourage any of our listeners who have a birth injury case sitting on the corner of their desk and need some help to reach out to Brian. He's very generous with his time and knowledge. We spoke about a case about a year ago that is now very successfully moving forward on the theory that you helped me develop, Brian. So I very much appreciate that. And I think we're going to get a good result for our client, largely because of your help.
Glad to hear that. And I do that for other attorneys. I mean, a couple came up to me a few years ago after hearing me talk at a conference and said they had a case they had declined. Hearing me talk, they thought, let's let this guy take a look at it. And I looked at it. I liked it. We litigated it, and we got a great recovery. And so I'm always happy to give attorneys a second pair of eyes, a second look at or third look at a case. We had another tremendous verdict several years ago in Oakland County, Michigan, the suburbs of Detroit. It was a $130 million verdict, largest judgment ever in the state of Michigan for a med-mal case. And that was a case that other law firms had turned down, came into our office about 5 days before the statute of limitations expired. It was a great case that people had not really appreciated for what it was.
Do you want to talk a little bit about that trucking case? I know about it because I've seen you and Tom and Judy present on it, but it's really a fascinating case and illustrates the power of really aggressive discovery and then also courtroom skill. Tell us a little bit about that one.
Sure. Well, I mean, first of all, it's one of the most compelling fact patterns I've ever seen. In fact, it's number one most compelling factual scenario of all time. Great family, the Adonisi family from New Jersey. The dad loved baseball. He had 3 kids, a son and 2 daughters. Zach was the son. From an early age, Dad wanted Zach to be a star pitcher, a lefty. And Dad would take that ball. Jude was the dad, Zach's the son. Jude would take that ball out of Zach's right hand, put it in his left hand. Hey, Zach, throw me the ball with your left hand. And wouldn't you know it, Zach became the greatest left-hand baseball pitcher in New Jersey. He was the National Gatorade Player of the Year in his sophomore year. And he had every college in the United States chasing him to go there. Eventually went to North Carolina and then transferred to Florida State. Definite major league potential. He just a great kid, by the way. Family life revolved around Zach's baseball career. Mom was a very lovely person, Natalie Adenisi. Her brother had just died after a long battle with cancer. So she flew out to Detroit to be with her brother in his final days. She flew out with the girls. Zach and Jude pack up the family van, get the girls' stuff in the back of the van. They're going to drive out and join the family for the funeral. They're on I-75 just outside Detroit. And there's signage, construction ahead, lanes closed ahead, several signs. They're moving along about 5 miles an hour. Along comes a truck owned by Challenger Motor Freight, 18-wheeler, driven by a gentleman who I'll tell you more about in a moment. He barrels into them at approximately 55 miles per hour, destroys their vehicle, and they're both killed. Family is waiting for Jude and Zach to arrive. They've ordered Zach's favorite pizza, Detroit-style pizza. And they're waiting and waiting, and they don't show up. Hours later, they get a call from the chief of police in their hometown that had been notified that Zach and Jude had been killed. So we get discovery, and turns out this driver has Parkinson's disease. And he's on heavy-duty medications for Parkinson's. And he has obstructive sleep apnea, and he's non-compliant with his CPAP machine. So this guy, who has pretty advanced Parkinson's disease, is on heavy-duty medications, has obstructive sleep apnea, is absolutely somebody who should never be driving a commercial vehicle, and fell asleep at the wheel and rear-ended them as if he had no idea that there was a slowdown ahead. And that's what that case was about. We went to New York at the defense request to have a facilitation, a mediation. They made a comment that unless we were willing to settle within their primary layer, they weren't going to make an offer. And, we quickly left. They never admitted liability until they sort of admitted liability on the morning of trial, but really didn't, because they, even their amended answer to the complaint that they filed after Tom Moore's opening statement was kind of ambiguous about whether they're admitting liability. The comments they made to the judge were ambiguous about whether they're admitting liability. But anyways, we proceeded to try the case. I had done all the depositions pre-suit. Tom took the lead at trial. Judy did a couple of witnesses. I did a couple of the troopers.
Talk about a dream team of lawyers. My God.
Well, Judy is an amazing attorney, amazing person, and has this aura about her that's so genuine and sincere and trustworthy. And Tom is Tom. Tom Moore is, one of the most articulate and spellbinding speakers you'll ever hear. He has charisma oozing out of every pore. He was amazing. He's just amazing to watch. It was a real treat to have a front row seat to watch Tom.
Yeah, and an incredible outcome in that case as well. What's the status of that? Is that fully resolved now, or are they appeal?
No. That's on appeal.
It's on appeal.
Yeah.
Why were they so emboldened to play hardball with you guys?
I don't know.
It didn't seem like a case that they had a good likelihood of success.
It's just one of those, it's mind-boggling. You have the nicest family you'll ever have. You have this aggravated fact pattern. And to, come and tell us they're not going to make an offer unless we agree to settle within their primary layer, it was just absurd. I don't know. Hubris, arrogance, I don't get it. And it was funny. The lawyer who I knew from Michigan, who'd come out to New York, as we're leaving, he looks at me and he winks at me and says, "Don't worry, we'll settle sometime." And I said, "Well, you think I'm worried about this case? Are you kidding me?" Like, no, I'm not going to worry. That's okay. Have a nice day. Just amazing. The arrogance of some people, it's just hard to fathom.
Just out of curiosity, on the verdict form, did the jury have to check off negligence, or was that already pre-decided?
You know, Raul, I don't actually remember. I mean, they did admit liability kind of during trial. The big part of the case was pain and suffering. And was there any pain or suffering experienced by these? And we called the neurologist who talked about, even though there was internal decapitation, they would have, first of all, heard and felt and seen the truck barreling down on them and know they were aware they were about to get hit and hit hard. And secondly, even after this moment, this horrific moment of internal decapitation, there's still mentation occurring in the brain. And he explained that, and it's just mind-boggling to think about what was going through their heads, even as their bodies, had been destroyed. And when the jurors came back and the foreperson, they asked if there was conscious pain and suffering. And he said, yes, in a very loud, emphatic voice. And I know that was really touching to Tom in particular.
In Michigan, do you have to, so are there caps on wrongful death recoveries? And in order to get pre-death, do you have to prove conscious pain and suffering?
There are caps in Michigan on medical malpractice and product liability cases. There are not caps on non-economic damages in motor vehicle cases. One of the hot button issues they have on appeal is whether or not we're entitled to pre-impact pain and suffering. And to my way of thinking, this is just a part of pain and suffering, which is clearly allowable under the Michigan wrongful death statute.
Interesting. Well, Brian, we're bumped up against our hour here, and it flew by. I really appreciate your coming on and chatting with us. This is fascinating. I mean,
I was happy to do it. And I'm sorry that you caught me at my worst with this horrible cold, but I was looking forward to doing this, and it was fun.
Oh, thanks for doing this, and then we'll see you.
Oh, my pleasure, Raul.
See you in
Yeah.
Nashville.
All right, looking forward to it.